Okay, there's another file. It's an 84-page file that's also from day 21. Anchorage, Alaska, Tuesday, June the 12th, 2012. Looks like it's going to be more questions for Coleman Barney. Call to order of the court, 8:39 a.m. This portion previously transcribed. The defendants present, jury not present. The clerk all rise. His dishonorable the court. This United States dishonorable court is again in session. The dishonorable court. Please be seated. Do you have any witness? Mr. Scrocky, no, Your Honor. We are resting. The court. Oh, okay. All right. Okay, I want to follow. I did a good job, I think, on jury instructions last night, so I'm way ahead of where I was afraid I might be. But it's still going to take us hours to get them finalized and copied and so forth. I think rather than keep the jury on ice, I'll let them go to come back tomorrow in instructions and argument. Can you give me a guesstimate of length of argument? I don't mean to hold you to time limits in this case, but for planning, I kind of need to know. Scrocky, I think about an hour and a half, give or take 15 for rebuttal. The court, affirmative. Traverso, best guess, maybe 45 minutes. Well, I'm figuring an hour, and my guy doesn't have as much as Schaefer, and I would figure at least an hour. I'm actually a little longer if possible. Well, is this tomorrow? We're going to do this, okay? Schaefer's attorney just said he needs 45 minutes, and Coleman and Vernon said they need an hour each. It's like Schaefer you would think would get 3 or 4 or 5 hours. Incredible. The dishonorable court, that'll give you an overnight to plan, which should make your argument shorter. Okay, well, after I excuse the jury, there's some things I want to talk to you about to regard to instructions. And then it's a matter of putting a trial set together and getting them to you for further discussion. But let's get the jury in here and take care of them. Mr. Dooley, yeah, Your Honor, before the jury comes in, yeah, I would like to make, yes, a formal motion on Rule 29, judgment of acquittal, on the same basis that we made at the close of the prosecution case. The motion is denied. There is sufficient evidence to carry the issue forward. Ms. Hayden and Your Honor, we also would renew our Rule 29 motion based on the argument that we made before, in addition to the testimony of Special Agent Westerhouse. The court, in the same ruling as to Mr. Vernon, Ms. Hayden and I would also again renew motion to sever based on particularly the rebuttal testimony. The court, yeah. Regarding Mr. Cox, also again denied. Okay, bring the jury in now. C1, Ms. Lamoureux, we still need to collect the transcript binders from the jury. The court, yeah, we would do that when they come in because they have their own stuff mixed up with it, I'm afraid. Ms. Lamoureux, okay, notes and stuff, so get ready to do it, but wait till they come in. The court, okay, Mr. Scrocky. Yes, Your Honor, the United States rest. Okay, now ladies and gentlemen, there's a lot more yet to do. Let's first take care of these transcripts, and they're going to pick them up from you so you can hand them back. I was afraid some of you might have your notes and so forth mixed up with those big books. The court, oh, now you lost papers out of that. Okay, that takes care of the first thing. You have not yet heard the instructions on the law, and you've not heard the argument of counsel, and so it's important for you to do the best you can to keep your minds open on all issues and not come to any decisions in the case until you've heard everything and until you've had a chance to discuss the case with your fellow jurors. So bear in mind, even though the parties have rested their cases, you have not heard everything. It is particularly important now that you follow my instructions about recesses. Don't discuss the case with each other or anyone else. Don't let anyone talk to you about it. Don't read, view, or listen to any news accounts of these proceedings. Don't do any independent research on the internet or any other way about that matters you've heard discussed. It's particularly important as the trial nears its end that you follow those instructions specifically. And bear in mind that if you don't follow those instructions specifically, we could end up with a mistrial, which means we'd have to start all over again with a new jury. You can imagine the problems that would entail. And I've never had to sanction a juror for not following my orders, and I surely don't want to start now. Now I'm going to let you go for the afternoon. That'll give us a chance, as you will see when you get the instructions on the law there. They will be lengthy. I'll read those instructions to you as I did the preliminary instructions earlier. But the lawyers and I have to work together to put the law and that applies into written form. And that just takes time, and it takes time to get those copied and ready for you. So I'm going to make you wait. So I'm not going to make you wait around this afternoon. You can take off, forget about the case, and do what you want within reason, and come back tomorrow morning at 8:30 ready to go. As I indicated, once we finish with instructions and argument, how long the jury needs to work on the case is a matter that's basically up to the jury. So I can't tell you when you'll be through yet, but we hope that you'll have the case in your hands tomorrow night. Argument may go over into the next day before we get the case submitted to you, but we're getting close to that point. Okay, so as I told you before, I'm not going to call your bosses or your spouses about getting out early today. So enjoy the rainy day. Be back tomorrow at 8:30, ready to go to work. Okay, thank you. The court. All right. Let's see what happens here. Jury not present. The dishonorable court. All right. There are a couple of issues I want to discuss with you so I can finish my preparation. In regard to count 8 against Mr. Barney, which is the charge of carrying a firearm in relation to a crime of violence, that the proposed instruction by the government asks the jury to determine which firearm was carried. I wonder if that's necessary in light of all the testimony in the case, that the jury be asked to determine what firearm was carried. It seems to me that it's a non-issue in light of the testimony in this case. Miss Lemerle, that's fine with us, Your Honor. Mr. Dooley, fine. The court. The dishonorable court. Okay, that will simplify that a little bit. It seemed to me that there was another one here I wanted to ask about, and I wanted to ask about defenses. Oh, no, I don't think I need to ask you about that. Now, there are 3 basic defenses that are raised here that I would like all the defendants to tell me what evidence there is to support these defenses and how they fit into the overall scheme here. And there are issues of entrapment, self-defense, and contingency. Contingencies, or whatever you want to call it. And before I finalize the instructions, I want to be sure I understand the defendant's position on those defenses and where they fit in. Well, the entrapment by estoppel is what we are referring to, Your Honor, where Mr. Cox goes to the ATF agent, the ATF office, and it's represented that the issue was homemade devices need to travel interstate commerce across state lines. The government called the ATF agent to impeach Mr. Cox, I presume, but the ATF agent also said that he may have talked about homemade devices and he may have talked about interstate commerce, but he doesn't remember. That does not exclude our defense, and even if the law at that time was that the interstate commerce doesn't govern homemade devices, the fact of the matter is he represented, even mistakenly, that he did, and that it did. So I don't know that there was a Stewart decision around that time. It's close to trying to figure out which occurred first, whether Stewart was decided or was the ATF agent operating under the assumption that you could say that homemade devices needed to travel interstate commerce. I think it's an entrapment by estoppel. He relied on it, whether it's mistaken from the officer or not. And I think that's where the defense on that instruction was proposed to the court. The court. Okay, any more on entrapment issue? Mr. Dooley. Yes, Your Honor. J.R. Olson brought up the issue of silencers on 26th of February. Prior to that, it had not been brought up. He, in my view, finagled guys into placing an order with a Class 3 dealer and then brought the samples with him on March the 10th and gave them to these fellows. And in my view, that was an entrapment. These people aren't necessarily buying an illegal silencer. Miss Hayden, I believe the entrapment, but also my argument would have to do with the silencer as well. Although Mr. Vernon did speak with Mr. Fulton down here in Anchorage regarding a silencer, when he returned to Fairbanks, he had no further contact with Mr. Fulton whatsoever. There was discussions here in Anchorage that in order for a silencer to be purchased, he would have to give the caliber of the weapon and the thread twist. He never did that. The silencer was re-emerged from J.R. Olson, as well as the discussion about hand grenades. Although there's discussion here in Anchorage, when Mr. Vernon returns to Fairbanks, there's no further discussion between Mr. Vernon and Mr. Fulton regarding the purchase. And just as a general proposition, I think it's clear that Mr. Olson did escalate topics and discussions throughout this investigation. The court. Okay, Mr. Scrocky, Ms. Lamoureux, on the matter of entrapment defense. Ms. Lamoureux, I'm looking at the model jury instruction 6.2 on entrapment, and there are 2 parts. The question of whether the defendant was predisposed or whether the defendant was not induced by agents to commit the crime. And looking at some of the case law cited, for example, United States versus Simmons, 9th Circuit, 1991. Inducement has been defined by repeated and persistent solicitation or persuasions which overcomes the defendant's reluctance. mere suggestions or the offering of an opportunity to commit a crime is not conduct amounting to inducement. Now, when Mr. Traverso raises the entrapment defense with regard to the conversation with ATF, I'm assuming that he's referring to count 5 alone, which charges Mr. Cox with the illegal possession of a machine gun. The elements of that crime do not require interstate commerce. When the ATF agent, Mr. Colhoun, was called to testify, he was clear that the interstate commerce element only is relevant in regard to felons in possession, for example, of firearms. It is not an element of prohibited firearms such as machine guns. The fact that it's a homemade is irrelevant. But the fact of this case simply don't support that Mr. Cox relied on that information at all. The information in the testimony at trial was that Mr. Cox had made his weapon when he was 16 years old, while the government thinks that there's also evidence that Mr. Cox did not actually make the firearm, given the expert's testimony that it was stamped as a Sten Mark II and it had serial number on it. It doesn't appear that Schaefer Cox relied on that information at all and does not warrant any type of entrapment defense. For sure, it doesn't rise to the level of inducement as defined in United States versus Simas. However you pronounce the case, SIMAS. With regard to Mr. Dooley and Ms. Hayden's request for an entrapment instruction, it appears that they're requesting that instruction with regard to count 1, which charges all 3 defendants with conspiracy to possess unregistered silencers and destructive devices. And that includes not only unregistered silencers, but the hand grenades, as well as the 37mm launches, together with the Hornet's nest rounds. The time frame of the conspiracy alleged is starting in approximately August of 2009. It's clearly that by November of 2010 for KJ&P at security team, which in all 3 defendants were present at KJ&P that night. The security team plans were that they were going to be armed with 37mm launchers and Hornet's nest round. And the testimony in this case supports that Mr. Barney clearly was armed with a 37mm launcher and Hornet's nest round. And defendants were aware of that. That was part of the plan. That did not happen. And that did happen. All of the defendants were predisposed to possess these items prior to Mr. Olson contacting them. And he did not induce them in any way, specifically with regard to the silencers. Okay, I'm going to take a break here on page 13. Taking a break on page 13. Okay, picking up with page 13, day 21. Silencers. What happened on February the 4th? Schaefer Cox directed Lonnie Vernon and Mr. Olson to get grenade bodies from Bill Fulton. When they're in Anchorage, Mr. Vernon asked Mr. Fulton for a silencer. Mr. Fulton and Mr. Vernon have conversations during that weekend in Anchorage where Mr. Fulton describes to him how the silencer would need to be lost first. There'd be no way that it would be an off-book deal, and he'd do it in a way so that there'd be no way to trace it back to him. During those conversations, Mr. Vernon also talked about grinding off serial numbers. It's clear that he was predisposed to possess those unregistered items before Mr. Olson raised the subject later on February the 26th. Turning to February the 26th conversation, what actually happens is Mr. Vernon tells Mr. Olson that he was talking with Lonnie about getting the silencers. And then Mr. Olson clarifies, actually it's me who's going to get those silencers from Bill Fulton, and again describes how those items are going to be lost and sold off books. Mr. Barney goes ahead and places an order for his silencer matched set that's going to be off books, just like Lonnie Vernon. And he also been told it was going to be off books, and then he showed up on March 10th, 2011 to purchase those unregistered items, both the hand grenades and the silencers. Again, in the vehicle in the drive over that morning, Mr. Olson describes to Mr. Barney and Mr. Cox how those items are going to be off book. So if they place another order for their 9mm silenced matched set that they wanted, then it would take some time because of the time to lose them. The defendants aren't charged with any substantive counts for the items that they purchased on March. The defendants aren't charged with any substantive counts for the items that were purchased on March 10, 2011. Rather, in count 1, they're charged with a conspiracy to possess a number of unregistered items starting from August 2009 going to March 2011. There's no evidence that they were entrapped with regard to the agreement and acts that they took in furtherance to possess those unregistered items. The dishonorable court. The count 1 is couched in terms of silencers and destructive devices. Should that be and or? Miss Lamro, yes, Your Honor. We always, in the indictment, we plead in the conjunctive, but would only need to prove in the disjunctive. And the jury would only need to find as to one object of the conspiracy to define the defendant's guilty on count one. The dishonorable court, all right. Miss Hayden, but Your Honor, I believe that the jury would all have to agree as to what item. In other words, you can't have half the jury convicting on silencers or half convicting on Miss Lamro. That's true. Miss Hayden, destructive device. Miss Lamro, we believe that that's addressed in the model instruction on the conspiracy charge, the dishonorable court. And in that regard, it is sufficient to say, as I think in the pattern instruction on conspiracy, that an instruction that all jurors must agree on a particular overt act that you find was committed, but there's no corresponding place in the proposed verdict form for them to make a finding as to which overt act. It is sufficient to instruct the jury that they must all unanimously agree on whether there were possession of silencers or an agreement to possess silencers or destructive devices, or both. I mean, you can do it in a blanket term and leave it to the jury, or you can put it in the verdict form. That wasn't a very good question. Miss Lamro, the government's position is that the instructions are clear enough. They do indicate, as you've suggested, that they need to agree on a particular overt act that they find was committed. And then also they must find that at least the model instruction 8.20 instructs the jury, you must find that there is a plan to commit at least one of the crimes alleged in the indictment as an object of the conspiracy, with all of you agreeing as to the particular crime which the conspirators agreed to commit. We believe that there is sufficient evidence we believe that is sufficient for the jury. The jury is presumed to follow the instructions and nothing further is necessary or warranted there. The dishonorable court, all right. Let's turn our attention to the self-defense issue. Mr. Traverso, at all times, Your Honor, with regard to post-June of 2010, Mr. Cox was very, very concerned for his safety, and those security details were not a ruse. They were actual things that he believed that he needed. Deadly force, if it's if deadly force is about to be committed upon you, you can respond with deadly force as long as it's reasonable and necessary to repel the other person. And I believe the government is concentrating on the KJNP events that occurred as the source or core of their dispute with us asking for that defense. This came up earlier in motions. I don't see how it is that the law is at issue. If there's deadly force about to be committed upon you, and Mr. Barney or Mr. Cox were very, very clear in their testimony, there's clear force, that deadly force is going to be committed upon you. You can use deadly force in response, especially under the circumstances as described. If someone is coming at you shooting and doesn't identify themselves, you can use deadly force. I'm not seeing the dishonorable court, of these Traverso, what the issue is there. The court, of these various counts, what do you think as self-defense applies? Mr. Traverso, I think it applies specifically to this conspiracy to commit murder. I believe that is totally an overreach by the government as to that. That's count 16, I believe. And that is, they believe that federal personnel were going to be at the KJNP radio station, but Mr. Sutherland's testimony was very, very clear. Nobody was going out there. So, but in the event that somebody was going to use deadly force, then these gentlemen were going to be prepared to use it if they had to. They were very clear from the whiteboard instruction that they were going to emphasize non-lethal force and do and don't, and is also not to shoot. So if the emphasis is to be peaceable about it, that certainly undercuts any argument that they were out there to promote violence. There was the dishonorable court. Okay, Traverso. There was no agreement for an unlawful objective of killing federal officials. And I think the jury needs to have some grounding. They've heard the facts. They need some guidance as to those facts. But otherwise, I think it'll confuse and mislead the jury otherwise. Mr. Dooley. First, I'll object to Mr. Traverso's use of the word killing. It should be murder. Killing, of course, is legal in many circumstances. Killing federal officials in their official role while they've, give up arrest where the FBI is not legal, of course. It was legal in many totalitarian countries for police or federal officials to murder people. We saw in the Nazi Germany, and of course I have no first-hand knowledge of that, but we don't have that concept in this country. Under I cited U.S. versus Spann, and that was a case where, in fact, the Ninth Circuit held that it was attorney, an ineffective assistance of counsel, for the attorney to fail to request a self-defense instruction, and in that case, there was an issue of whether U.S. Marshals were acting outside the scope of their proper role. This case has plenty of facts by which these fellows are simply concerned about what they perceived as a Ruby Ridge type problem, and that there could be some people coming at them that don't identify, don't announce themselves, and start firing, that's all. Miss Hayden. And certainly, Your Honor, for the crime of conspiracy to exist, there has to be an agreement to do something unlawful. If indeed self-defense is justified when you're being unlawfully fired upon by anyone, your right to return fire to defend yourself would be lawful act, and therefore would come under the conspiracy agreement. And I think that that should be explained to the jury, and if the agreement was if we get in a position where our lives are in danger, we can certainly respond. If that's the agreement, then there's no conspiracy. Mr. Traverso, Your Honor, if I may I'm sorry, I forgot, there is absolutely no prejudice to the government with that jury instruction, none whatsoever. In fact, what it does do better than anything is make sure the jury has a focus and grounding on how to decide the events of KJ&P. And so there is no prejudice and there is no misapplication of the law that's going to apply here. In fact, it's just the opposite. The court, Miss Lamoureux, with regard to this proposed, I believe that this is proposed with regard to count 12 for the conspiracy to murder federal officials. And as defense attorneys have argued here, they can argue before the jury that there was no agreement for unlawful killing or to murder. There was no agreement to murder because it was an agreement to use self-defense. And that's what they argue here, and that's what they can argue to the jury. The jury will be instructed on the elements of the crime of conspiracy to commit murder. Obviously, the defendants here are not charged with murder or attempted murder. The government has also proposed an instruction regarding the underlying offense, so that the jury understands what the elements are for the underlying offense in order to have an agreement to commit that offense. There are arguments that can make to the jury. These are arguments that they can make to the jury, but a self-defense instruction is not warranted when the defendants are only charged with an agreement to commit murder and then taking overt acts in furtherance. We don't get to place where they are exercising any sort of self-defense, specifically with regard to KJ&P. They were anticipating. They left their homes armed. They were anticipating some sort of confrontation with law enforcement. It didn't happen, so therefore, no self-defense instruction is warranted to talk about the use of force they thought they may or may not have been necessary. That's crazy. Ms. Lamoureux is absolutely insane. You have the right to self-defense all the time, 24/7. You don't get to pick and choose the times you have to self-defense. That's me talking, by the way. Picking back up with a transcript. The other thing is that count 12 is a conspiracy to murder federal officers and employees of the United States starting in August of 2009 through March of 2011. There's been testimony from Michael Anderson, other testimony of the other federal officers' names who showed up on his paperwork because those people were being targeted. There's no self-defense argument whatsoever with regard to these specific federal officers, employees whose names made it on the list, and their facts don't support any instruction with regard to that portion of the charge. Okay, thank you. Miss Hayden, Your Honor, if I can she's raised an issue and I think we need to address, and that is that count 5 has both the 6 fictitious FBI agents and then members from Homeland Security, that the names that Miss Lamoureux, count 12, Miss Hayden, count 12. Miss Lamoureux, you're talking about the conspiracy to murder, Miss Hayden. Yes, Miss Lamoureux, okay. Miss Hayden, both fictitious FBI agents and the other federal officers that are those being people whose names allegedly appear on Michael Anderson's list, I think there absolutely must be a specific special verdict as to the dividing those two issues. The 6 fictitious FBI agents are related to KJ&P and the other individuals are related to the list, and they don't seem to intermingle as far as I'm concerned, and I think there ought to be a specific verdict given to the jury on that count. Ms. Lamoureux, government does not think that this is warranted. In this situation, defendants do not even need to know the victims or federal officers or employees. That's very clear in the case of law. For example, Romero case from the Second Circuit, where defendants were set up as a stakeout for their drug deal to protect the drug deal. They didn't know who was going to show up. Federal agents showed up and they were charged with conspiracy to commit murder. No special verdict form here is necessary with regard to specific individuals. the dishonorable court. Let me point out to you, if you want a particular verdict from a form, a particular instruction that you haven't already requested, you better get it in quick. I've been drafting and redrafting on these for a long time, and it's not my job to redraft everything that you might think you might want. It's your job. So if you have requests that aren't in what I already have, you better protect your record by getting it in. Let's talk briefly, hopefully, but talk a little bit about the contingency issue. Mr. Traverso, the government has outlined in its purpose of the conspiracy, Your Honor, that the actions of the militia, or that is of Mr. Cox, Mr. Barney, and Mr. Vernon, were based on in preparation of the eventuality that the government will collapse. Chaos will ensue, mob rule might be around, or it might be either private or government. They have emphasized this in the indictment. Case law that I cited to the court on our Rule 29 motions, Anello and Dworkin explain, and I'll read a quotation from that. For purposes of criminal conspiracy, virtually all agreements are to some extent conditional. The test for conspiratorial liability should focus on the likelihood that the condition precedent will be fulfilled. And that's in keeping with the model penal code and other case law. So their point is everything that has been done, all the circumstantial evidence that they have put forward, and some of it also they claim to be direct evidence, all of this has been because they believe that Mr. Cox, even though they have not charged him as an overthrow, their theory is that Mr. Cox other gentlemen were going to engage in the overthrow of the government. That is in conflict with the other part of their indictment, which talks about, well, when the government collapses, whenever the eventuality occurs, then these gentlemen are going to take action pursuant to the indictment, which stated in the indictment. Those are at cross purposes. You, on one hand, are saying that something's going to happen at some point way down the road. We don't know when, and nobody certainly is going to be able to say what that is, and I haven't seen it in our history anyway. And number two, they also have trying to say that they are going to overthrow the government now. So anyway, those are in conflict. But here is a conditional precedent that must be established. And that is, if it's reasonably believed that this condition would obtain, and I believe the government should not be able to, on the one hand, say that this condition precedent is here, but there's no way to deal with that as a matter of law. They're saying that there is conspiracy automatically, regardless of this condition. But the case law suggests otherwise. This is a very unusual case. I haven't seen a case like this before. I don't think there is a lot of case law on this point, because this is a very unique indictment that the government is seeking. So conspiracy law hasn't caught up with this kind of situation that they're presenting. But I believe the case law under Anello and Dworkin, I can give you the cites of that if you wish. The dishonorable court. I think I have excuse me. The dishonorable court. I think I have them, but Traverso, okay, let me ask you this. If the jury should be instructed on contingency, what is the standard? What you just read to me from that one case, it sounds like Traverso, okay. The dishonorable court, where he talks about the reasonable likelihood or something, but that's not, what is the standard of proof? Traverso, if the defendant reasonably believed that the conditions would obtain, this is a citation that is not a meandering, actually. I don't want to say that you're wrong, Your Honor, but case law that was part of the opinion of the court, not something that was just excess intellectual viewpoint on this. The dishonorable court, senile deaf judge. Well, if that's the standard, then if a defendant reasonably believes that a condition will occur, it would include the little green men from Mars. Mr. Traverso, but reasonable, the dishonorable court, because some people believe in them. Mr. Traverso, but reasonable is an objective standard. It is not subjective only, it is objective. So we would have to have a definition, which I did not propose to you, of what reasonable is. But if it's reasonable, then that's an objective standard, but subject of course, what each of the defendants believe themselves. But reasonable is what a larger community of people would think. And so we need to make the distinction to the jury that you're following an objective standard of what reasonable belief is, not necessarily what Mr. Cox believes. And the government is basically referring to this indictment when they say that this eventuality it's such a loose-ended phrase, and yet you're saying that we know that there are cross purposes when you talk about. Hold on, I lost my spot. When you talk about whether something's objective and whether something is subjective, the court. Well, I don't think we're talking here in this regard about government collapse. We're talking about agents appearing without identification. Traversal, either drawing down on somebody or right. Starting to shoot somebody. Traversal, right, that is true. Little green men coming out off the mountain, or people jumping off from a spaceship headed to Earth. The point of the matter is it reasonable to believe that this condition precedent is going to be met? And they have a good example. If somebody's trying to buy marijuana at 3 cents a kilogram and you're asking for lots of kilograms of marijuana, that's ridiculous. I believe that there's no way that nobody can predict something like collapse of a government, or in this case, little green men coming down from the mountaintop. Mr. Sutherland clearly testified in this case that there was no expectation that anybody was going to go there from the federal government. The court, okay, Mr. Dooley, I join in his arguments, but this contingency is similar to what we've studied in law school about the fellow who made a threat and was charged with assault, in which he said Middle Ages. If it weren't for the assizes being here, I'd punch you in the nose, or something to that effect. And that was not assault because there was no imminent issue. The contingency issue is simply another brand of that type of thinking. If they're going to, they have the burden of proving, the government does, that these fellows were intending to kill federal officials in the course and scope of their proper duties. If they can show that that was going to happen, they may have something. But anyway, that's all in there. The dishonorable court, senile deaf judge. Yeah, you started your discussion with something to the effect as we studied in law school. Traversal, under tort law. Dooley, oh, I'm sorry. The dishonorable court, that's assuming that we studied in law school. Traversal, okay, which many people think probably didn't happen in my case. Mr. Dooley assumes we went to law school, so the dishonorable court, well, I did do that. Miss Hayden, anything else on this subject from you? Miss Hayden, I agree with Mr. Dooley's analysis. I do think it has to be contained to the KJ&P and whether or not federal agents existed or were going to show up. Traversal, Your Honor, in my protective order motion that was denied a while back, I cite the case law regarding what I believe Mr. Dooley is referring to. There's actually an old Washington case that was cited, and it's based on an old instruction from Prosser that you can't have a contingency assault under those circumstances. It's in the motion for a protective order prior to the superseding indictment. Ms. Lamoureux, there's a long history of case law regarding the elements of conspiracies charged under Section 371, and the likelihood of conditions being fulfilled is not an element that is required. It's an additional element the defendants are requesting here, but it's only going to confuse the jury, and none of the cases cited by the defendants propose adding an additional element, propose asking the jury to determine the likelihood of whether the contingency or condition was likely to be fulfilled. The state's instructed to find whether there was an agreement, whether there was a meeting of the minds, and based on that instruction, that's when they have this discussion amongst themselves, whether there was an agreement and whether somebody became a member and joined it in and took an overt act in furtherance of it. These are all arguments that the defense counsel can make to the jury, but it's not an additional element of the crime. And they're focusing their arguments on KJ&P, but the conspiracy to murder, as I've indicated before, is starting in August of 2009, continues through March of 2011. They were expecting federal agents to show up. Mr. Cox had acts of war lists that he had checked off. He had declared war. He was anticipating federal agents showing up. But regardless, there's also the list of the specific individuals on it, people they were targeting. The condition precedent is just going to confuse the jury, and it's not something that's warranted by the case law. The dishonorable court. Okay, it's 11:30. I'll work as fast as I can and have a discussion set of instructions ready for you as soon as they're ready. And I don't know how you notify each other around here, but my best guess is an hour or so. I should have a trial set to you. I'll do the best I can, but somebody should be ready to pick them up or get a call or whatever. However you do it, around here, whenever. Mr. Dooley, can we give cell phones to Denali's cell phone number? The court, she's nodding. Miss Lamoureux, On another matter, Your Honor, this morning I noticed that Mr. Dooley emailed a word-perfect version of his proposed instructions to that email address you gave us yesterday, and it did contain additional instruction that I don't think was in the set that he had filed on TMECF. Dooley, that's correct. Miss Lamoureux, so for the record, we should, if Mr. Dooley could file that would be great. Dooley, okay. The court, what was the subject of the additional instruction? It was a contingency instruction. Oh. Traversal, yes, Your Honor. This may be presumptuous on my part, but I have asked from the very beginning of the case, especially when the government was doing the audios, that we should have proposed First Amendment jury instructions. I don't know if that was going to be on the table of discussion here this morning. It will be later when you get my trial set. Traversal, okay. The clerk, all rise. This matter stands in brief recess. The clerk, all rise. His Honor, the court, the United States District Court is again in session. Please be seated. Often at this stage of a trial, I meet with the counsel in chambers, go over instructions, but it seemed to me, since this is a criminal case, and the size of it, legally the size of it, would be better to do everything in the courtroom. I'm sure the defendants are interested in this as well. Now, I guess what I want to use this section for is for you to point out to me any typos you found and anything that needs to be changed, and we'll take formal exceptions after the draft is perfected. So I guess I should ask the government to go first and tell me where I've erred. Miss Lamoureux, Your Honor, may I remain seated? I don't care. Miss Lamoureux, in our proposed jury instructions filed at docket 305, we requested a couple of standard instructions from the model jury instructions, which I didn't see in the court set. The court, and what are those? Miss Lamoureux, one of them was the deposition as substantive evidence. It's the model instruction 2.6, given that those two videos depositions are played for the jury. The court, I think I gave instructions orally during the course of the trial. Miss Lamoureux, okay. I don't think it's necessary to give it again. Miss Lamoureux, okay, that's fine. We also requested 4.3 other crimes, wrongs, or acts of the defendant. The court, I thought that was covered by 3.10, which is in your set. 4.3 and 3.10 is a little more generic. Miss Lamoureux, that's fine, Your Honor. I just wanted to raise it. The court, yeah. Miss Lamoureux, you did conclude an instruction with regard to testimony of the witness involving special circumstances, which is the model 4.9. And I believe in the language in the court's instruction, it references benefits received by the witness. The court, yeah, give me. Could you tell us what number you're referring to, the number of my draft? Miss Lamoureux, it's number 11, and that's based on model 4.9. And the only thing I wanted to point out was there was a witness who had immunity in this case. I thought that you should insert the word immunity. The court, that's 4. What? Model 4, the model number is 4.9, yeah. It's the court's instruction number 11. Yeah, what about that from the defendants? I'm fine with it, sir. I'm fine with it. Inserting the word immunity, the court to add to it, yes. Traversal, no opposition. Okay, we'll add the word immunity between received and benefits, and I've got to get a system to mark these. Okay, what else you got? Miss Lamoureux, the court's instruction number 30, which provides general instructions about conspiracy and acts and declarations of co-conspirators. Affirmative. Miss Lamoureux, the government has proposed an additional paragraph following the first paragraph that those acts and statements. Wait a minute, give me a number so I can look at it. The court's instruction number 30. No, your number. Our proposed jury instruction number 6. I took out your second paragraph. Yes, Your Honor. Is that what you're talking about? Yes, that's just a comment on the evidence. Consider the evidence for all purposes unless it's limited. So I don't know any reason to tell them you should consider that or you may consider that. Miss Lamoureux, okay. The court, I come from a background on state court where there's constitutional prohibition against the judge commenting on the evidence. I try and avoid that. I thought this was a comment on the evidence. You guys can comment on the evidence all you want, but I don't get to. Miss Lamoureux, that's fine, Your Honor. The next instruction we'd like to raise is the court's instruction number 48, which is the instruction on the underlying offense of murder of federal officers and employees. Yeah, the Lamoureux. The self-defense language in there does appear to track the model instruction language, with the addition of the sentencing that a killing in self-defense is not unlawful. The government notes that in other cases involving self-defense allegations, and the government would request an additional sentence given that addition of self-defense language, that those general principles must accommodate a citizen's duty to accede to lawful government power, and the special protection due federal officials discharging official duties. And I'm reading from the United States versus Branch case, which is citing the Supreme Court case of United States versus Fiola. Mr. Dooley, did you say it's instruction 40 or it's the court's 48? I'm sorry, it's court's instruction 48. 48, thank you. Miss Lamro, the additional request the government makes is an addition of the line that the defendant does not have to know that the victim was an officer or employee of the United States. The court, I figured you'd raise that. And you charged him with killing an officer or an employee of the United States, so I think you can come along now and say it could be anybody else, can you? Miss Lamro, our position is that they are officers and employees of the United States. The court, yeah, so why would you put in there something that is contrary to the underlying charge of conspiracy to murder officers and employees of the United States? Miss Lamro, well, it's not. This is the instruction regarding the underlying offense. The court, yeah, so with regards to the conspiracy that's charged in this case, we definitely will prove that. The court, yeah, Miss Lamro, the agreement was to murder federal officers and employees, but when we turn to the instructions for the underlying substantive offense, they need not know that the victim was a federal officer or employee. That's an accurate statement of the law. The court, I'm going to write down the language you suggested here. Give me language you suggested. From the case, yeah. These general principles must accommodate a citizen's duty to accede. Just don't go so fast. I only write so fast. These general principles must accommodate a citizen's duty to accede to lawful government power and the special protection. Just a minute, accede to a citizen's duty to accede. Miss Lamro, must accommodate a citizen's duty to accede to lawful government power and special protection due federal officials discharging official duties. The dishonorable court, senile deaf judge. Special protection due, Miss Lamro, federal officials discharging official duties. The court, who wrote that? Miss Lamro, it's the Fifth Circuit in the United States versus Branch case. The court, sounds like something a circuit judge would write. You know, we're instructing a jury here. I hear what you want to say, but that's terrible language to put in a jury instruction. That's what the term unlawful means. I can parse that out for you if you want. First, general principles referred to are not real clear when you just throw it in, these general principles. To accommodate is not a very clear word in this circumstance. You don't know what a citizen's duty to accede lawful government power is. Accede is a terrible word for jury instructions. There's no evidence of what the citizen's duty is. And I don't know what special protection federal officials discharging official duties have. It invites the jury to speculate on those things. You know, when you say use of force is justified when a person reasonably believes it's necessary for the defense of oneself or another against the immediate use of unlawful force, you know, what you're suggesting is that you want to add that federal officers, it's not unlawful for federal officers to arrest under proper circumstances or something. But that's the whole issue of unlawfulness. That's what they describe as their underlying Ruby Ridge stuff, is that the force exercised by the officers was unlawful because they didn't identify themselves and they just started shooting. That's not what happened at Ruby Ridge as I understand it, but that's kind of beside the point. That was what they thought, but if something happened in the way they were concerned about, then it's unlawful force. If it's an attempt to arrest and make a proper arrest, it's lawful. So what I have to say about, you know, when is it lawful and when is it unlawful? Do you want to get into a whole deal about the power of arrest, the duty of citizens? Nobody's asked for that, and I think your proposal is not, for the reasons I've indicated, is not good instructing. Miss Lamro, could we have the time to confer on this, Your Honor? The court, sure. Miss Lamro, yeah, and you know these aren't final till they're final. Miss Lamro, thank you. The court, and obviously I haven't heard from other parties on that issue either, so what else you got for me here? We'll come back to that as necessary. We had requested an instruction on false exculpatory statements. Yeah, and what is your instruction number what? Lamro 32. The court, and I'll tell you why I left that out. I left that out because number one, it's simply a comment on the evidence. Number two, you can argue that without instruction. Number three, your source, federal jury practice and instructions, is a terrible source. I've thrown down the gauntlet that I could take any page in that book and show you what's wrong with the instruction that they put out as a pattern. And so I don't think you need that. The jury can figure out what to do with that kind of evidence, and you can argue everything that's in the instruction. Okay? And then in the special verdict form, the court, yeah, we just noticed that at the end of the verdict form, there are two additional lines which we're not familiar with. But perhaps it's this. They were in your proposed verdict form, weren't they, Julie? Miss Lim, I thought so. Miss Lamro, they were not in our special verdict form. The court, no, I don't have it in front of me, but Miss Lim, indiscernible preliminary instructions. The court, pardon? Miss Lim, maybe it was in the preliminary instructions. The court, oh, maybe it was. That's ordinarily not in a verdict form, and Miss Lamoureux, we would request a deletion of the court. Yeah, I think that, Miss Lamoureux, those sentences there. The court, dishonorable court, we don't need to remind them at this point because this is not an instruction, it's a verdict form. So we'll take that out. Miss Lamoureux, and then in the special verdict form as well, the court, the dishonorable court. I just called it a verdict form. I don't think there's anything that makes it special here. Miss Lamoureux, special in the verdict form at the beginning where the defendants are charged in count 1 with conspiracy to possess unregistered silencers and destructive devices. We're wondering if we should add an and or given the language instructing them that they need to agree. The court, yeah, probably. Miss Hayden, I'm sorry, counsel, which instruction? Miss Lamoureux, on the verdict form. Miss Hayden, on the verdict form, okay. Miss Lamoureux, on the questions regarding count 1. Okay, going to pause here on page 41. Pausing on page 41, day 21. All right, here's day 21, picking up with page 41. The court, the dishonorable court. Okay, what else you got? Miss Lamoureux, believe that's it from the government at this point, Your Honor. The court. Miss Lamoureux, there was one typo, Your Honor. A typo. Miss Hayden, number 24. That wasn't the one I was looking at. Miss Hayden, oh. There was, you're right. Yeah, you're right, yeah. Miss Hayden, number 24. Miss Lamoureux, paragraph 1, Mr. Cox's name is not spelled right. There's just a capital C. Where is this now? In the court's instruction number 24. What page? Page 1. Ah, got us on that one. Okay, that it? Yes, Your Honor. Traverso? I think the judge knows where I'm headed. Yeah, I'm sorry, Your Honor. I'm not wearing my sports coat. It's a little hot in here for me. The court, that's all right. I don't care. Traverso, all right. Proposed the First Amendment instruction at 15. It leaves out a significant part, which I believe is the First Amendment, in which we presented as our defense. In this, the law that I cited came straight from the U.S. Supreme Court. Advocacy of force is not proscribed unless it is, and we can use a different word if you wish, but advocacy of force is not prescribed unless it is directed to inciting or producing imminent lawless action, and is likely to incite or produce such action. I think the jury needs to be able to distinguish the different types of advocacy here, and that's where the government can argue, if it wishes, that the advocacy of force that perhaps they want to say that Mr. Cox was asserting falls outside the First Amendment speech. We presented through many witnesses, testimony and cross-examination, as well as just direct examination, that none of the things that Mr. Cox stated in their opinion incited or produced imminent lawless action. And I think that's got to be clear to a juror. I could see that perhaps the rest of I thought my First Amendment instruction was really short, but yours is even shorter, and it leaves out, I think, the most important part of our defense. Let me look at yours again here. Pause. Well, yeah, I hear you, and it may be that should be somewhat strengthened. Let me suggest this for discussion. We could add after the language even a provocative, challenging, or offensive manner, comma, and even if the speech advocates the use of force. The last sentence of that instruction tells the jury that they need to know in terms of handling such expressions, that is, do they relate to the charges in this case? Mr. Traverso, I think that's Miss Lamoureux. Could the court please repeat the proposed change? The court, once more. Add the comma at the end after the word manner in the second line, and even if the speech advocates the use of force. That's fine with us, Your Honor. It still doesn't correct without the word imminent in there, because there's the court, well, Mr. Traverso, different kinds of force. That which is, if you say advocacy of force versus advocacy of force of imminent lawless action, then you've got a just clear distinction there. One says one's okay, the other's not, and then they see the clear line. And I asked all the witnesses, pursuant to the Supreme Court decision, whether or not Mr. Cox's speech had that effect, which is, did it produce in your mind an imminent lawless action, or did you think he was advocating imminent lawless action? The dishonorable court, well, the only lawless action that we're concerned about here, Mr. Traverso, affirmative. The dishonorable court, are the charges against these fellows. We're not concerned about other lawless action or whether there's other imminent force. Traverso, right. The court urged Mr. Traverso, well, I don't have a problem with that last sentence that you put in your instruction in number 15, which says, you should consider such expressions of such beliefs only insofar as such expressions are evidence relating to one or more of the crimes charged. I don't have a problem with that being included, but I mean, First Amendment law is centered on the last sentence, and I have just brought forward, in fact, there's litigation nationwide regarding this. The dishonorable court. Just a second. Well, here's the problem with your position as I see it. With that language in, then you're saying to the jury that the advocacy of force, wait a minute, I lost my thought there. Deaf and senile, can't hear, he just lost his thought. He admitted he lost his thought. He was in the middle of a sentence. He says, you're saying that to the jury that the advocacy of force, wait a minute, I lost my thought there. It's like he's the judge and somebody's going to determine whether somebody spends life in prison. Well, I guess what I'm trying to say is this. Advocative, we're not talking about prescribing speech. We're talking about what speech is evidence of the offenses in this case. And while advocacy of force may not be prescribed, it may be considered by the jury in determining the intent involving these offenses and other things. So I think that language doesn't fit the facts of this case, is what I'm saying. Mr. Traverso, I think what you can do to remedy this is that language is fine if there is a further instruction. If you believe that the advocacy of force, as presented in this case, is circumstantial evidence of the crimes charged, that I think you can reconcile those two. But just saying flat out that advocacy of force, that doesn't produce imminent lawless action, let me rephrase that. The last sentence is straight out of the Brandenburg case, Your Honor, and it doesn't remove the jury's consideration to consider this still as a circumstantial evidence. I'm not saying by this instruction that you cannot consider the advocacy of force as circumstantial evidence of the crimes charged. I'm just saying that the First Amendment language includes what I've asserted in this paragraph. I'm not saying that it cannot be used as circumstantial evidence. The court, I don't agree with you. I think you're adding that limits the freedom of speech of Mr. Cox in this case beyond what it needs to be limited. I just simply don't agree with you on that analysis. Okay, what's next? Traverso, I don't know if someone else wanted to speak up about something. Ms. Lamro, we noticed a couple of other typos if you want, Your Honor. What? Yeah, where are they? Well, we're on instruction number 15, the second sentence. All people have a constitutional right, to express. The court, too many rights in there. Okay. Ms. Lamro, then again, back to the verdict form in question number 18, there's a typo with a period after count 12 instead of a comma. Affirmative, okay. I take it, Your Honor, you're not going to give an entrapment by estoppel instruction? I don't think the evidence supports it. Incredible. Traverso, I want to assert for the record, Your Honor, that we believe that them calling the ATF agent plus Mr. Cox is the court, yeah. Traverso to testimony. You can get to that in the Traverso, right. Formal exceptions. We're not to formal exceptions yet. Mr. Traverso, oh, sorry. The court, I'm just trying to see things that we might change here at this point. Traverso, okay, sorry. So you can take your exceptions from the final. Traverso, okay. The court draft. Any other things you might give me to prevail or prevail on me to give you? Ms. Lamro, we just noticed something else in the verdict form, Your Honor. Quit that. What else? Ms. Lamro, in questions 10 and 11 regarding counts 7 and 8, 924, there should probably be a reference back to the conspiracy charge in count 1 to parallel the way that the questions are structured for the 924Cs in questions 18 through 20. The court, Lamro, so in questions 10 and 11 to add during in relation to the crime of violence, that is, the conspiracy charge in count 1. Okay, just a minute. I should be consistent in the same thing in the next paragraph. Ms. Lamro, yes, Your Honor, all right, you're right. Okay, keep looking, you'll find some more probably. Mr. Traverso, anything further at this point? Mr. Traverso, I don't know if I left this out or I thought it had been in there. Something about what defines possession. What defines possession? I don't know if I left that out. The court, yeah, that is one that defines possession is after the first time in the instructions when possess is used, which is in count 1, so it follows count 1. Traverso, okay, I must have, and of course applies to the other, must have run through that pretty fast. Instruction number 27. Oh, yes, okay, that's fine. The court, yeah. The dishonorable court. Traverso, and that was my mistake, Your Honor, apologize. The dishonorable court. That's all right. I thought that's where I had it. Isn't that after the first conspiracy charge? I believe so. Traverso, you have it after the dishonorable court. Yeah. Traverso, yeah. The dishonorable court. Okay, lots of instructions. Traversal. That's all I have, Your Honor. The court. All right, Mr. Dooley. Mr. Dooley, yes and thank you. Instruction number 12, talking about informants, and I think we ought to plug in right here into this instruction, that Sears instruction. That's pattern 8.6 from the Ninth Circuit patterns, which state that you have a conspiracy just with an informant. And Your Honor, I'd actually submitted that Mr. Vernon's jury instruction D, well, it's not 8.6 because that's assault. It's 8.26. 2.6, Ms. Lamerell, the evidence doesn't support a Sears charge in this case, Your Honor. Okay, Mr. Dooley, give me a fact pattern to support that. Mr. Dooley, we have various people agreeing with J.R. Olson to do things, but they have to agree with each other to do things. For example, the conspiracy to possess a silencer, the way I view the facts was simply people talking to J.R. Olson, the government informant. The court, there's no conspiracy. However, if the only person with whom the defendant conspired was a government informant, Mr. Dooley, that's fine. Ms. Hayden, Your Honor, I actually like the wording that I submitted in my proposed instructions better because it names the informants, just so there's no confusion. And that's at page 10 of docket 321. It's what? Page 10 of docket 321? The dishonorable court. I don't think, oh yeah, here. No, you can argue that. It's covered. Ms. Hayden, yes, sir. The dishonorable court. Okay, what else you got for me? Mr. Dooley, I have, although the overt acts of the government start out with the overt acts alleged in count 1 of the indictment include the following, and then they list them, I would like a specific instruction that we have not agreed to these overt acts. An initial reading made some people at least think that this had been proven, and an instruction essentially that the defendants are not in agreement. These are not stipulations, and the court itself does not, well, whatever. And I'm looking at instruction 24, which is very first overt act instruction. The dishonorable court. Okay, let me just look at that. Insert after indictment, at least one of which must be proven by the government beyond a reasonable doubt or something. Mr. Dooley, I just want an initial reading of this caused at least one person to think that this had been sponsored by the government. The dishonorable court. No, I don't sponsor. Mr. Dooley, so the dishonorable court. I don't sponsor these. If it was up to me, I could probably say something a whole lot different, but this is Mr. Dooley. Well, we could simply say the overt acts alleged by the U.S. government or by the government in count 1. Ms. Hayden, and I kind of like the language must be proven beyond a reasonable doubt. The dishonorable court. Okay, I'll do something with that. I see where the issue is. And what is the second? Okay, here it is. 47 is the second one. All right, what else you got, Mr. Dooley? Mr. Dooley, Mr. Dooley, I'm on instruction 26 now of yours, and I'm going to refer, well, to statute 5845F. The dishonorable court, which I don't have before me. Did you refer to one of your instructions? Mr. Dooley, I did not refer it to in one of the instructions. I can bring you my book. The dishonorable court, well, I don't know what your problem is with this. Mr. Dooley, okay. The court, is this something wrong with it? Mr. Dooley, it leaves out elements of the offense of 5845 because there has to be propellant charge of more than 4 ounces. Ms. Lamerell, that's not required by law. That's not the court. Ms. Lamerell, that's government position. The court, I looked up the statute about 20 times and I didn't come up with that as a requirement for this. Mr. Dooley, a rocket having a propellant charge of more than 4 ounces. Well, if you hand me your book, I can, Mr. Dooley, write the court and look at it, Mr. Dooley. And the next one was an incendiary charge of more than 1/4 ounce, explosive or incendiary. The court, no, I think these are accurate. The proposed instruction, I think I read that statute. I don't think it's necessary to add what you propose. Mr. Dooley, okay, next one, instruction 27, the dishonorable court. You got to wait a minute. My hearing aid just gave me a signal that the battery died. Oh, gosh. Oh, he can't hear anything. You got to wait a minute. My hearing aid just gave me a signal that the battery died. So if you want me to hear you, you got to wait till I put in another battery. Mr. Dooley, all right. This old age is just not that great, you know. Okay, Mr. Dooley, I think I'm organized. Mr. Dooley, next one is the court's instruction 27. I think that's incorrect under U.S. versus Hurd. Hurd was the homeowner. He knew of the presence of illegal items. He had in fact helped put them in the garage, but the court said he had to exercise dominion and control. Poor words for an instruction, but it's stronger than what we have here. I think the one here is the pattern instruction, court, isn't it? Yes, Your Honor. Mirrors instruction 317. What's the pattern instruction 317? Well, I guess the bottom line is I'll go with the circuit on this. The circuit committee, I think it covers the concept of dominion and control, and the case that this is based on is later than Hurd. And you don't have to own something to have possession of it. Okay, what's next? Mr. Dooley, next 1 or 2 instructions, 43 and 45, and they had to do the hornet's nest and the 37mm launcher. The statute by Congress says that the item, the launcher, had to have been, well, what it says, the term destructive device shall not include any device which is neither designed nor redesigned for use as a weapon. And earlier I had asked for a motion for reconsideration on a motion on that topic, and the court, if I can find that thing, had left it as a jury question on that issue. I'm trying to find that document. The court, yeah, I know I did. I think I changed my mind. Mr. Dooley, but that would be terrible, because they should be determined that the launcher has been designed or redesigned for use as a weapon. The court, I don't think that's required. I think once you add an anti-personnel round to a launcher, those two things together make a destructive device. But the anti-personnel round regulation doesn't reconcile with the statute. The court, how do you mean that, Mr. Traverso? Well, the 8, Traverso, just as the language he quoted it. I don't have my indiscernible. Mr. Dooley, I'm not. Traverso, on that Mr. Dooley, I don't see in this statute, and it's the same one, anti-personnel rounds. Mr. Traverso, that's an administrative ruling. Mr. Dooley, that's ATF stuff. And internal regulation by ATF 99.5, whatever it is. Dooley 95.3, Traverso 95.3. What's the number of the destructive device statute again? It's 5845 subsection F, and it's toward the end of the subsection. The court, aren't we looking at part 2 of subsection F that says any type of weapon by whatever known name which readily converted to expel a projectile by the action or an explosive or other propellant, the barrels of which have a bore more than a ½ inch with some exceptions? Or is that the one we're talking about? Miss Hayden, that's correct, Your Honor. Mr. Dooley, well, that's the one the government's talking about, and I'm talking about, I guess it's subsection 312, in which there is an exception. The term destructive device shall not include any device which is neither designed nor redesigned for use as a weapon. The court, why don't you put one of these hornet's nest in there? It's designed for use as a weapon. Mr. Dooley, well, so are darts and dartboards and blowguns and a bunch of things, but the launcher hasn't been designed or redesigned for use as a weapon. The court, until you put a hornet's nest in there. Traverso, yeah, but Dooley, that doesn't affect the design or redesign of the launcher, which even a felon can have. The court, well, Traverso, I would submit that the dishonorable court, we're talking about the launcher by itself, nor we talking about the hornet's nest rounds by themselves. It's a combination. Mr. Dooley, there's nothing in the statute about a combination. Mr. Traverso, Your Honor, if a hornet's nest is an anti-personnel round and the jury can lead itself to conclude that in itself prohibited because of the words anti-personnel, which comes from the ATF, it didn't come from the statute. The court, it come from the evidence in the case. Traverso, it came from the regulation, and the regulation says anti-personnel round, and the jury's going to think, well, if I buy a hornet's nest, it's prohibited automatically, and that's not the law. The court, well, Traverso, because we ask their government's witnesses, can you buy a launcher? Are they readily available? Yes. Can you buy a hornet's nest? Yes, they're readily available. But if way this is read, anti-personnel means it's against the law to have a hornet's nest, and that's not the law. The court, I think it's the law if you combine it with a launcher. Traverso, well, then the language anti-personnel should be excluded from there and should make the determination that the hornet's nest was combined with the launcher. But it shouldn't be characterized as anti-personnel. Anything can be anti-personnel. The court, I'm not sure what you're suggesting. Change should be made to 44 and 45, Mr. Dooley. But the government must show that the launcher was designed or redesigned for use as a weapon. I suggested that they could argue that putting in the hornet's nest in it is a redesign, but I would argue it isn't. But I think they could argue that to the jury. The court, I don't think that's the section of the statute that you're talking about. You tell me. Miss Lamro, yes, Your Honor, I think we've litigated this already, but we're in section F2. Any type of weapon as indicated by the court's instruction number 26, any type of weapon by whatever name known which is readily converted to expel a projectile by the action of an explosive or other propellant, the barrel or barrels of which have a bore of more than 1/2 inch in diameter. The government's position is that the launcher with the hornet's nest round together fit with expel a projectile, fit that definition. Well, I think those are accurate instructions. What else you got for me? Mr. Dooley, that's all, and I didn't find any typing errors. The court, I'll probably find someone I read the instructions. Okay, you're just laying in the weeds for me back there, I expect. Yeah, Miss Hayden, no, Judge, I only have 2 things, and one is in my proposed instructions, I asked the court to give a multiple conspiracy instruction, and that's at docket 321, page 9. The court, just a minute, let me turn my page. The dishonorable court, that does, Miss Hayden, see, the dishonorable court, and that's not covered already? Ms. Hayden, well, Your Honor, there may be, the evidence I believe shows that there may be more than one conspiracy here, and the jury needs to determine which defendant, if any, belong to which conspiracy and who makes up that conspiracy. I think we've got so many people in and out going over such a long period of time that this instruction is warranted. The court, when I looked at that, and my impression that every sentence in it is covered by other definitions of conspiracies and so forth. Ms. Hayden, it's a pattern instruction, Your Honor, 8.22. Well, that doesn't mean that you have to give it in every case. What I'm looking for is the evidence that there would support that instruction is not covered already in some other instruction. Ms. Hayden, I believe this makes it more simply for the jury to understand, given the conspiracy law is quite complicated. Ms. Lamoureux, the government's position is that this instruction is not warranted here. The instructions are clear to the jury in terms of what they're supposed to consider and find. There's no evidence that there was another conspiracy going on. They're charged with a conspiracy with multiple objects in this case, and they're instructed on that they must unanimously agree as to the object of the conspiracy. But in this case, there's no need for multiple conspiracy instruction. The court, the comment indicates use this instruction when the indictment charges a single conspiracy and the evidence indicates two or more possible conspiracies. There are two conspiracies charged here. The instruction is couched in the singular. I wouldn't fit that case as it stands, and it reads as though the only offenses charged were the conspiracy charges. So as it stands, the instruction is not appropriate in this case. The concept, I don't think so. You can submit a proposed instruction if you want that might fit, but I don't see the need for it here. Ms. Hayden, yes, Your Honor, my final subject is a proposed instruction that I found, filed around noon today. Hopefully the court received it and received it by email as well. It's at docket 421. Okay, I'm on page 61. Page 61 on day 21. Going to take a break. All right, picking up with page 61. The court, I didn't see it, did I? Or is this? I don't think so. Miss Hayden, no. Let me take a look what you got there. Okay, make her bring it all the way. My clerk she is how we do it. Right in front, so I discern them. Here normally, that's how she used it. The court, papers to the clerk, but nobody has to move very far. Oh, the withdrawal, Miss Hayden. Yes, Your Honor, I think the evidence supports that Mr. Vernon withdrew from any conspiracy involving Mr. Cox and Mr. Barney on the 19th of February, and I think that was further demonstrated today by Special Agent Westerhouse's testimony regarding Mr. Vernon's intent in intending to acquire the silencer and not related to the Alaska Peacemakers Militia or the Alaska Assembly Post. And again, Your Honor, that is a pattern instruction. That is what a pattern, I'm looking at that's what a pattern, yes, sir. Comment on the pattern. Now, my impression was that there is not sufficient evidence of withdrawal, assuming membership in a conspiracy before that time. I don't think there's evidence of withdrawal that would support this instruction, but tell me, Miss Hayden, speak to the evidence, Your Honor. I mean, the 10th, it looked to me like whatever conspiracy there was, he was still in on it on the 10th. Miss Hayden, well, Your Honor, I believe that the evidence shows that after the meeting at Mr. Barney's house on the morning of the February 19th, when Mr. Vernon discussed the problems, the court, Miss Hayden, that he was having with Mr. Cox. He left, and then Mr. Cox left his home, and I don't believe there was any communication between Mr. Vernon and Mr. Cox during that time period. J.R. Olson approached Mr. Vernon after that time period regarding silencers, and Your Honor, I don't think there was any evidence that Mr. Cox nor Mr. Barney had spoken to Mr. Vernon about silencers before the trip to Anchorage. The court, what did he do to withdraw from the conspiracy, assuming there was a conspiracy to begin with? Miss Hayden, he served his communication with Mr. Cox. He severed his communication with Mr. Cox and severed his communication with Mr. Barney as to any type of destructive device, silencers, or anything of that nature. I think Mr. Barney testified that there was one conversation where he dropped off a chair, but no discussion regarding anything that could be the subject of a conspiracy. Ms. Lamoureux, the court previously heard argument on these facts at the Rule 29 stage. The court to the Ninth Circuit case of 1992 of United States versus Lothian, Lothian, 976 F.2 D 1257. The Ninth Court sets the standard that to withdraw from a conspiracy, a defendant must either disavow the unlawful goal of the conspiracy, affirmatively act to defeat the purpose of the conspiracy, or take definite, decisive, and positive steps to show that the defendant's disassociation from the conspiracy is sufficient. There's no evidence that Mr. Vernon withdrew from the conspiracy. Yes, on February 19th he had words with Mr. Cox, but there's evidence This is Mrs. Lamoureux. There's no evidence that Mr. Vernon withdrew from the conspiracy. Yes, on February 19th he had words with Mr. Cox, but there's evidence in the record that he continued talking with Mr. Barney in particular about silencers. And then specifically on February the 26th, the beginning of that conversation, Mr. Barney thought it was Lonnie Vernon who was getting the silencers. And then, of course, they remained in communication leading up to March 10th. And then on March 10th, he knew that Coleman, Barney, and Schaefer Cox were also getting the illegal weapons from J.R. Olson. And he purchased illegal weapons from J.R. Olson that day. There's no evidence that he withdrew from the conspiracy, and that instruction's not warranted here. And the grenade, too, yes. The court, pardon? Miss Lamoureux, and grenades, too. In addition to silencers, he purchased grenades. Miss Hayden, Your Honor, I believe the evidence shows that it was communicated between Mr. Vernon and any other defendant. It was communication between Mr. Vernon and J.R. Olson. The court, it's the case that Miss Lamoureux cited from, but I guess we're sticking, in my mind, is why it's the clerk. You need to get closer to the microphone, the court, the dishonorable court. Maybe we should make Matt hand them down to you. The clerk, Judge, you need to get closer to the microphone, please. The court, no, I'm telling secrets. The clerk, oh, okay. The court, I'm used to a court reporter. I don't think the evidence supports the withdrawal instruction. Miss Hayden, yes, sir. Okay. Anything else on these now? Yeah, Mr. Dooley. Mr. Dooley, yes, Your Honor, I completely fogged out on something, and going back into the court's instruction 27, one of the elements of the government must prove is stated in Staples versus U.S., and let me say the right words here. Miss Lamoureux, which instruction, Mr. Dooley? I'm looking at court's instruction 27 regarding possession. Mr. Dooley, yes, and essentially the government is required to prove beyond a reasonable doubt that the defendant in this case knew that the weapon he possessed had the characteristics and brought it within the statutory definition of a machine gun. And that is at the court, at page 602 of the app page, and that's the most important thing I had and fogged out on it, and he must know that it brought it within the statutory definition of a destructive device. The court, I finessed that by taking that language out of the instructions defining machine gun and saying you had to know it was a machine gun, which is the same as what you read, only less confusing and confounding. But I didn't see it in regard to the Hornet's Nest destructive device. Miss Hayden, is it included in the court's instructions? I'm not sure. I slipped a cog here somewhere at the last part on the Hornet's Nest. Miss Lamoureux, the duly Miss Lamoureux. The third element in the court's instructions, 43, 44, and 45, indicate that the government must prove that the defendant knew that it was a 37mm launcher loaded with a Hornet's Nest anti-personnel round. That's the element that satisfies the Staples requirement. The dishonorable court, it does. It doesn't tell the jury anything to say they had to know it comes within the confines of this language of the statute or whatever that is. I think I'm correct on that. All right, anything else before I have these corrections corrected? And I would say in regard to the instructions that it's never too late until we start instructing, but I'm going to finalize these and ask you to take a formal exceptions to these today, and then if there are any last minute things, we'll take a look at them, and I would want to have them before 8 in the morning so that we can instruct the jury at 8:30 hopefully. That would give us time, if necessary, to make any last minute changes. All right, Lamoureux. Is it the court's practice to instruct the jury before closing arguments? Always. I can't imagine anybody in this day and age doing it any other way around, but some judges live in the past. Scrocky, Your Honor, with respect to the landscape for closing argument, do you want to have it in the same as opening statement? The podium here? Stick to the podium. If we have exhibits, we can grab them off the table and show them to the jury. The court, that's what I would prefer. Yeah, Scrocky, all right, thank you. The court. I think you need to, be able to be closer to the jury, but I don't like you climbing in the jury box. Now let me get these started, and before we take formal exceptions, I want to talk about the managing exhibits during deliberations. Let me get this started, and don't go too far. It won't take long. All rise. This matter stands in brief recess. Jury not present. The clerk, all rise. His dishonorable, the court, the United States Dishonorable District Court is again in session. The dishonorable court, please be seated. Okay, the record should show that I have made corrections that resulted from our early informal discussion. The instructions number 1 through 56, and also I've handed those to counsel, and also a verdict form, and that is the instructions. Those are the instructions in the verdict form that I propose to read to the jury. So now comes the time for the formal exceptions to those instructions. The daughter of Belial, Miss Lamoureux. The government maintains an objection to the self-defense language that is included in instruction number 48. We reviewed the pattern instruction 6.8 on self-defense. For the most part, the language in the court's instruction 48 tracks it, but then it adds there's an additional sentence that a killing in self-defense is not unlawful. In this sentence is confusing and appears to reiterate some of the information that's already included in the 2 paragraphs preceding. The government would request that the sentence be deleted somehow if the government's not inclined to delete it, to wrap it into the first paragraph somehow so that it's clear that this is all part of the same defense instruction. The court, okay, Ms. Lamoureux, I mean if the government requests that it be deleted, but you know the first paragraph could read use of force and killing in self-defense is justified when a person reasonably believes, or something along those lines. To clarify that the court's intent is with that last sentence there. The court, go ahead. That's it, Your Honor. That's it, Ms. Lamoureux, yes. The court, the dishonorable court. Okay, Mr. Traverso. Mr. Traverso. Your Honor, I take strong exception to the court's First Amendment instruction. I take strong exception to the court's First Amendment instruction. It is not consistent with the U.S. Supreme Court's decision on imminent and defining force and defining the scope of force when it occurs. 2, we also take strong exception to the court not giving the entrapment by estoppel as to the counts involved. The count involving this machine gun and home and silencer, both were homemade. Now I know the court the government has asked, is arguing that the stint is not, that their expert believes that it's an auto and that it's not a homemade device. But the government is relying on Mr. Traverso. Mr. Traverso, magazine well that had a serial number, and that was the only part of it that he focused on. And Mr. Cox explained that he built the whole thing, the rest of it himself, except for that one part that he retrieved. Now, so there were 4 witnesses who testified as to the ATF discussing interstate commerce. Michael Anderson did, Philip Clark did, Mr. Cox did, and even the ATF agent did. But he's foggy in his memory about what he specifically said about homemade devices. But he says he wouldn't normally do that, but interstate commerce was discussed. But he doesn't remember how he discussed it other than he said about probationers or people who were crossing state lines. And that frankly was beyond me. But also I think as to the instruction regarding hornet's nest, the statute does not use the words anti-personnel rounds. That is a regulatory language that is used by ATF, and it suggests it gives cause for the jury to infer that a hornet's nest is in and of itself illegal because of the words anti-personnel are placed in front of it. We've previously, as the court and as the government has pointed out, we have previously litigated this language. I had challenged it and it being unconstitutionally vague, and I know the court denied the motion. But at least as far as the jury instruction is concerned, I do think that anti-personnel rounds should be excluded. The court, okay, Mr. Dooley, Your Honor, Coleman Barney joins in the objections of Mr. Traverso to the instructions, particularly instruction 15, the First Amendment instruction. It should have eminence words in it. Sorry, I'm still flipping. I object to instruction 26 for the reason stated in the informal discussion. I object to instruction 27. For reasons stated, I don't want to belabor. I want to continue to object to the instructions related to carrying a firearm. That's instruction 40 specifically. There's another one to a crime of violence for the reasons I stated earlier in our motions. The conspiracy to possess something is not a crime of violence. That would be 40 and 42. The court, one of the bad parts about the law, the crimes of violence, is that ordinary English and the law don't coincide. Mr. Dooley, and I object to the dishonorable court, senile deaf judge. I think the Congress ought to and the courts ought to not do that as they do it. Mr. Dooley, and object to 43, 44, and 45. They had to do with the hornet's nest, and I believe instructing in that the jury should be given a decision to determine whether the launcher itself was designed or redesigned for use as a weapon, and I object to the use of anti-personnel language. I also think that Lonnie Vernon's instruction C would be appropriate, and I think and object to it not being included. And I believe the contingency instructions of various kinds, there should be at least some version of contingency instruction. And of the, now I'm fogging out again, what was the other topic? Estoppel. And the language and the possession should carry with it. That was 27, that the defendant has to know that what the characteristics are that brought it within the statutory definition of a destructive device. And it's so vague, and the rule of lenity should cause these men from having a hornet's nest with a launcher. That concludes it. The court, okay, Ms. Hayden. Ms. Hayden, yes, I'll join Mr. Traverso and Mr. Dooley in objecting to instruction number 15, and join Mr. Dooley, I'm sorry, it escapes me on which one, the possession of instruction. I too believe that the defendant must know the characteristic that make the item a destructive device under Staples. I also object to the court not giving my proposed instruction C and proposed withdrawal instruction. The court, okay, and I'll join in a withdrawal instruction objection. The court, okay, to prove I was paying attention in law school, Mr. Dooley, I recall one day, my third year, we were having a variety of lawyers come and talk to us about various practical aspects of the practice of law. And this one fellow said in regard to exceptions to instructions that you should assume that you've lost the case and your only chance is to get the judge reversed on appeal. And that's how you ought to look at exceptions to instructions. Anyway, that's one of the nuggets I remember from law school. Okay, I want to caution about suggesting to the jury that they get playbacks of testimony. That will be very difficult in this case. I usually don't allow it anyway, and you got all kinds of problems if they do a request a snippet, and may end up having to sit there for hours listening to the whole witness testimony or whatever. And it's very hard to pick out what's been played and what hasn't been played from these tapes. So anyway, that's one problem I hope we can avoid. As to exhibit handling during deliberations, I don't know what the volume of exhibits is going to be here when you put them all in one place. And I don't know if you all have thought more about that. But I would welcome your ideas. Denali said that whoever they is, the government, I guess, the federal government may want to use this courtroom while the jury's in deliberation, which may not be a very practical idea. But what are your thoughts on that? Mr. Scrocky, we're prepared to have everything available for them in the jury room if it'll hold it. The court, well, if it'll hold it. Mr. Scrocky, that's the unknown as far as we understand. The court, you mentioned earlier that it was your practice to give them the guns with a trigger guard or whatever on them, but not ammunition. Scrocky, we're prepared to do that unless they have a specific reason the ammunition's really not all that important as we see it. The court, well, they have a right to look at it if they want. Scrocky, they do, and maybe they could ask if we want to see it. They can send a note out, we'll provide it. I don't know, well, the jury room hold all this stuff. Scrocky, Denali, I really doubt it, but we could take a break and we could look at the jury room. The court, well, we can do that. I mean, that's the best if we can do it. I guess everybody probably agrees with that. The clerk, if they don't mind sharing the bathrooms with it, we might be able to get it. We might be able to get it to work. Pardon me, if we don't mind the jury sharing their bathrooms with the evidence, it might work. Their what? Bathrooms. They have some large bathrooms back there. The court, okay, why don't we take a look at it? We can discuss that informally. The other thing is tomorrow I'd like to have counsel available at 8. So if there are any suggested additional instructions, we can take a look at them and make changes if you convince me to do that. And so we can start hopefully promptly at 8:30 with the jury. I'll take probably most of an hour to read the epic set of instructions, and then we'll go right to the argument, okay? Mr. Scrocky, Your Honor, on that note of argument, I have in the past in this courtroom set up a small table in front of the jury box and put a monitor on that table. The court monitors? Scrocky, a computer monitor. Oh, Scrocky, so when you argue to the jury, you're not spinning your head back and forth at the PowerPoint presentation. And so my suggestion would be, and I've spoken with Denali about this a little bit, is there a small table over there we can put in front of the bench? It'll also keep us away from the table. If you want to put some evidence on it, we could, but put a monitor right there so you could present and look down when you needed to and not take your eyes off. As long as it's equally available to counsel, it's all right with me. Sure, I have no reason why it wouldn't be. The court, okay, anything else we ought to talk about before break? Okay, I'll be here and available at 8, and we'll plan to start at 8:30 unless somebody wants to present something earlier, okay? And counsel, after the defendants go down, you can come back and go look at the jury room together. The clerk, all rise. This matter is in recess until tomorrow morning. The court is adjourned subject to call. Okay, I think I've got 4 more pages from day 21. Let me find that document. Oh, my goodness. Okay, this is day 21, 4 pages. I'm not sure what order it is. It occurred on Tuesday, June 12, 2012. Anchorage, Alaska. Call to order of the court at 8:39 a.m. I guess it occurred very early in the morning. Jury not present, all parties present. The clerk, all rise. His dishonorable, the court, the United States District Court of Alaska is now in session with the dishonorable Robert J. Bryan presiding. The court, please be seated. I might tell you this morning I feel a lot better about jury instructions than I did last night. My assistant is in there just typing furiously, so we're on the schedule with that, and I gather there are a few more questions of Mr. Barney. Mr. DeVerso, I'm going to withdraw any application to ask any questions of Mr. Barney. Are there any other questions of Mr. Barney? Not here, not from us. No, sir. Okay, you can step down. Wow. Okay, I guess that occurred right in the beginning of the morning. All right, let's get this uploaded to YouTube for day 21. We'll jump over to day 22 next.